Entertainment Law Update, episode 175 for Monday, December 30th, 2024. Hi, everybody, and welcome to another episode of Entertainment Law Update from Los Angeles, California. I am Gordon Firemark.
And from the Dallas-Fort Worth Metroplex, I'm Tamara, Bennett.
And we thank you so much for being here with us for this final episode of 2024. This is our podcast about entertainment law, where each month we pull together a roundup of legal and business news stories and share our opinions and commentary and analysis about all those things. And as we do every December, although we're late in December now, we were going to do a little bit of a recap of some of the big stories from 2024 after we cover some of the newer breaking stories that have happened in the last few weeks. So first of all, what's new with you? How was your Christmas?
Oh, Christmas was fantastic. Thank you. How about you guys? How were your holidays?
Christmas and Hanukkah. Hanukkah's still going, but very nice, very lovely. Quiet, sticking around the house mostly. Had my mom and sister and her family over for dinner a couple of nights before Christmas, just because I was scheduling convenience. But
Sure.
it was a lovely evening and nice to spend some time with everybody. And
Yeah, we did too. We had a Tennessee Christmas.
Nice.
So with my mom and extended family, and got to see aunts and uncles from both sides of the family. So that was great. And my mom lives out in the country, so Christmas morning, my niece makes an awesome TikTok or video of the deer choreographed a Run Run Rudolph.
Yeah.
So,
Oh, nice.
all we were missing were a few snowflakes. If only we'd had a little bit of snow, that would have just completely capped it off.
Okay, interesting.
Yeah.
Nice.
Yeah.
Well, we're going to start off the show with just a little bit of sad news, but about a life well lived, I think it would be reasonable to say. President Jimmy Carter passed away on December 29th at a ripe age of 100 years old. He was the American politician and humanitarian who served as the 39th president of the United States from 1977 to 1981. And although he didn't get to appoint any Supreme Court justices during his one term, he did appoint a large number of lower court judges. In 1978, a new law created 152 new judgeships that he was able to fill. And that gave him the opportunity to become the first president to really meaningfully diversify the federal bench in terms of gender and race and so on. And he received the Nobel Peace Prize in 2002 for his humanitarian work. So it's certainly a life worth celebrating and a man of respect.
That's right. I remember Home on a Snow Day in whatever would have been if he started in his 77, must have been in the winter of 76. And and I was young. I was young in 1976.
Me too.
Yeah, right. And he was on the local, what was called the noon show, the local news at noon. And that iconic "I'm Jimmy Carter and I'm running for president." And it's interesting what an impact that had on me, even probably because it was somebody who sounded like me and was from somewhere close. So yeah, a life well lived. So
oh, that's cool.
I love it.
I had the good fortune to have a brief conversation with him a couple of years ago. Two different clients of mine have situations in which we needed rights from the Carter family, and it was just one of those things where he actually jumped on the phone with us and one of his representatives just to hear what I had to say, and everything went smoothly. It was really cool. So
yeah, it's amazing. It's amazing. Well, may he rest in peace, and his lovely wife as well. So.
Yeah. Well, you have some upbeat news to report about your
I do
practice.
have some exciting news. So, effective January 2nd, I am pleased to announce I am joining the Dallas law firm of Harper and Bates LLP. I'm going to join them as a partner with Shannon Bates and Scott Harper. They have a lot of skill in business litigation and intellectual property protection, which really complement my existing practice. And so, for 25 years, I've been helping all types of clients protect their IP, whether it's artists, songwriters, music publishers, businesses. And I'm really excited to take that part of my practice and combine it with their practice and add new things for my clients to have access to. So, patent prosecution, IP litigation, business litigation, and they also have a niche in aviation litigation. So,
Oh,
after 25 years in practice and 23 years in solo practice, this is a big change for me
yeah.
in some respects, but in other ways, I feel like it's going to be business as usual. I'm coming to us live today from my office in Louisville. I'm going to keep having my office in Louisville, Texas, which is a suburb of Dallas. So I'm very thrilled to be able to do that. And then I can be in Dallas as needed
Hmm.
for meetings or appointments. So super excited to be joining the team at Harper and Bates.
Wonderful. Congratulations. That's very
Thank
nice
you.
and
Thank
exciting.
you.
Yeah.
And folks can still, I know we'll give all where we can reach each other at the end.
Hmm.
You can still reach me at all the normal, all the normal ways for probably a long time to come. I'll have just more ways you can connect with me. But again, after 23 years, that phone number and email just are not going to go away. So
Well,
you can still reach me.
yeah, but great to have some added infrastructure and support systems in place,
That's right.
and the opportunity to serve a broader variety of folks and
Yeah.
and have, well, the support really, I think, is a lot of it, isn't it?
Yeah,
So.
yeah, just to have the support of more administrative staff, partners, senior associates,
Hmm.
just I'm excited about it. It's going to allow me to do things that, as a solo, we can do so much, and that's okay, and that's been great. But this is just the next chapter in how I can help the people I can help the most, which has been my motto for several years.
That's great. That's great. Well, um, let's get into some of the news recently. There's been a lot of back and forth news in this field of the Corporate Transparency Act and the deadline that was tomorrow for reporting your beneficial ownership information if you own a corporation or an LLC or lots of other kinds of entities as well. That requirement of reporting was enjoined by a court in Texas, and it was a nationwide injunction on the enforcement of the law. That was December 3rd. Federal Judge Mazant in the Eastern
Yep.
District of Texas issued an 80-page order granting a nationwide preliminary injunction against enforcement of the Corporate Transparency Act. The judge stated that the act is likely unconstitutional as outside of Congress's power, and because of those reporting rule implementations, unconstitutional for the same reasons. So then on December 23rd, the Fifth Circuit reinstated that requirement, overturning the injunction, extending the deadline for a couple of weeks to the 13th of January. And then on the 24th, the plaintiffs and appellees sought an en banc review of the Fifth Circuit's decision, requesting a full rehearing, and that rehearing has been granted, further suspending the operation of the act until the hearing, which is, I think, scheduled for March or something. It's possible the government will do something to the Supreme Court for an interlocutory relief from the injunction
Hmm.
sooner, but at the moment, the Fifth Circuit's position is that in order to preserve the constitutional status quo while the merits panel actually considers the parties' arguments, then the order granting the motion to stay the injunction is vacated. So we're back to no requirement to file the BOI just yet. So stay tuned.
Yeah, and I'm going to give Gordon a two thumbs up because when we first talked about this new requirement early last year, you said, I think a lot of people, I don't think this is going to fly. I mean, you had some comments about
Did
that.
I say that?
Well, you said a lot of your clients were hesitant to report, maybe, or maybe not your clients, but you'd heard people
Yeah.
were hesitant to report for a variety of reasons and disclosure. And I think you did it.
Yeah, I think there's a lot of folks who use corporations and LLCs and trusts and things like that for purposes that are, really fairly private purposes. I mean, you want to, a celebrity wants to invest in real estate. It's probably not something they want to do in their own name. They're going to do it through a corporation or a family trust or something like that. And having to report this information, even though the government says it's going to be kept confidential. We know from experience with, things like the Trademark Office and other
Yeah, that's exactly what I was
agencies.
thinking. Yeah,
That doesn't always work the way we plan,
right.
um, and so those privacy protections are significant. On the other hand, as I've thought about this, I will say that I think that the anti-money laundering purposes of the act and some of the other rationale behind creating the act are going to satisfy even strict scrutiny in terms of
Mm,
compelling government interests. It's the question of whether this is narrowly tailored or not, I think, is going to come down to how it gets decided. So we'll see what the courts think.
yep. There you go. We'll have more to report
Yeah.
at sometime in probably first quarter.
Yes. Yes. Why don't you take this next one?
Sure. So it's a follow-up on a case we just talked about a few months ago, the Internet Archive, Hatchet Book Group versus Internet Archive. As we reported back in episode 172 this past September, the Internet Archive lost its appeal in the copyright case against Hatchet and three other publishers. The Second Circuit Court of Appeals has affirmed the previous decision from March 2023 that the Internet Archive's open library program qualifies as copyright infringement or is a copyright infringement, but
Is.
is copyright infringement. And the Internet Archive did, as far as we can tell, did not file a petition for cert to the Supreme Court, so the Second Circuit ruling will stand.
At least until there's another circuit that rules differently on a similar case, and then we have,
Yeah.
a reason to see the Supreme Court jump in.
So it'll be interesting. I mean, we've been watching it for a variety of reasons over the years, but I've accessed material from the
Mhm.
Internet Archive before. I will say the things that I have accessed intentionally would be in the public domain
Yeah.
based on the year of creation and publication. But I've also run across people trying to do the right thing and accessing material from Internet Archive, and we have to go,
Yeah.
if you use that, we've got a lot to deal with. So,
Yeah.
yeah, I haven't gone back to see kind of what's been cleared out of their database or
We should be
blocked from
clear
their
that it's not the
database.
whole Internet Archive that's
That's
been
right.
ruled infringing. It's just the copying of books that are still under copyright protection, where the archive was actually, creating an open library project where they
That's
were going
right.
to have the full text of the books available. But
And I did not check the status on the record labels that have sued and the
mm,
publishers. So I suspect something is moving on those as well.
I would expect a similar
Yeah.
ruling in that kind of a
Yeah.
situation, especially given this ruling. But things like the Wayback Machine, the part where you can go back and look at what a website looked like 20 years ago, something like that. That's still going to remain, and some pretty valuable tools in there for folks. If you're not aware of the Internet Archive, it's worth a good look and just to see what's there. So.
Yeah. It's got some cool stuff, but then it's got the other stuff.
Mhm. Yes, indeed. Well, some infringing and some not, apparently.
And some not. It's a
Well,
hodgepodge.
speaking of infringement cases, the Katy Perry case has arrived at a ruling. This is a federal court in Australia involving a case involving the music artist Katy Perry, whose real name is Catherine Hudson. And she was sued by the Australian fashion designer Katie Taylor, who trades under the name Katie Perry. In 2008, that designer registered her trademark for the name Katy Perry for use on clothing and fashion design. And that registration occurred despite and possibly because of the designer's awareness of the pop singer's growing reputation on the international pop star roster. Katy Perry, the artist, filed for her trademark on June 26th, 2009 for music-related goods and services as well as clothing, and later deleted the Class 25 clothing from her application in order to overcome an objection based on that earlier fashion designer registration. She had adopted the stage name Katy Perry all the way back in 2002 and was selling branded merchandise, including clothing, handbags, totes, t-shirts, caps, those kinds of things, as early as 2009 in Australia. And so the designer rejected a cease and desist from the singer's team and pursued trademark infringement claims of her own after sending a letter of demand 10 years later, 2019. So at trial, the Federal Court of Australia found that the singer and her company did infringe the designer's trademark, but other companies linked, is this right? Other companies linked to the singer, Killer Queen LLC and Perfect Ventures LLC, were not liable, and the singer's cross-claim to cancel the designer's trademark was dismissed. So there was both sides appealing parts of the ruling. On appeal, the legal issues looked at the scope of the designer's trademark, and the ruling was an upholding of the trial judge's finding that the designer's trademark applied only to clothes and not to headgear and footwear, and emphasizing that the trademark owners have to clearly define the scope of goods covered by their registrations. And because that designer hadn't explicitly included headgear or footwear in the trademark specification, she was going to be out of luck on those particulars. On the joint tortfeasor liability, that's against these companies, the court held that Katy Perry and Bravado International were joint tortfeasors, but Killer Queen and some of the other merch companies were not. And the rationale there was that joint liability depends on the specific roles and contractual relationships, and Killer Queen is a passive licensor, and the contracts with the merch companies did not establish any kind of joint tortfeasor relationship. On the own name defense, the ruling held that the singer could rely on the own name defense, but it didn't apply to the companies. And on honest concurrent use, the ruling was that the court found the singer's use of the Katy Perry mark in 2009 was honest but not concurrent, so that defense failed. So to qualify for concurrent use, the mark must have been used in a non-infringing manner prior to the priority date of the designer's trademark, and that was not the case. Finally, cancellation of the designer's trademark registration. The court canceled the designer's trademark under two different sections of the Trademark Act in Australia. Section 60, the court held that the singer's mark had a reputation in Australia before the designer's priority date. And given that reputation and the common practice of musicians selling clothing and merchandise, the designer's mark was likely to deceive or cause confusion. And another section 88.2c, by 2019, the singer's reputation has significantly grown, increasing the likelihood of consumer deception regarding the designer's goods. And her refusal to accept a coexistence agreement, apparently offered by the singer's team, and attempts to align her brand with the singer further supported the finding that this was sort of opportunistic registration and use of the trademark.
Wow.
So the court overturned the earlier decision and canceled the trademark registration and lifted the injunction against the singer's companies and ordered the designer to pay legal costs. So,
Yeah. We did talk about this earlier.
yeah, I
May
think
of 2023, episode
okay,
157. Yeah, so it's been
a year and a half
18
since
months
that.
ago. Yeah, since then. And obviously this is in relationship to Katy Perry and Katy Perry in Australia.
Yeah.
Does not necessarily have a direct impact to any filings at the U.S. Patent and Trademark Office or enforcement of those rights. So.
But still interesting to see trademark law being applied in other places, pretty much the way I would expect it to be done here if something similar were to happen, don't you think?
I guess so, even though obviously we have a concurrent use defense. I don't think it's the honest concurrent use defense. I mean, or the own name defense. You know, it's interesting because Katy Perry is not her name.
It's not her real name, yeah.
It's not her real name. I don't know how that would work in the US unless she had legally changed her name. I don't know. I mean, it's her professional name.
Mm-hmm. Yeah. I found myself wondering also if the ruling that the designer's mark applied only to clothes and not headgear and footwear would be the same here, or would we say, well, it's still in the same class and it's going to be, well, actually that it wouldn't be the same class, but you know,
No, it would be.
likely to expand into those fields might
Right.
have.
So hats and shoes are class 25, just like
Oh yeah,
shirts and
t-shirts.
tops. So I think they would say that's a natural expansion.
Mm-hmm. Okay.
I don't know. I mean, it probably will do the same. I think there just might be some different rationale for a few things. I don't think they would have canceled her trademark.
Probably. Well, yeah. Well, would they have forced a coexistence in that consideration? I don't know. It's kind of,
I don't know. I don't know.
especially with the designer coming in after the singer had already started to be in the field, or around the same time, I guess. Well,
And we haven't seen the evidence to see
yeah.
if there was evidence of
Oh, come
what
on,
they.
evidence, please.
I know. Evidence, evidence. Let's make up a word there.
Yeah. Well, do you remember? Let's move on to the next story. You remember in January of 2023, we featured an interview with Alicia Calzada, who is the Deputy General Counsel to the National Press Photographers Association, about that filming permit situation in the
Hmm.
national parks with filmmaker Gordon Parks. Well, last week the Senate passed the Film Act, and thank you, hat tip to Alicia for reaching out to us and letting us know about this. In a follow-up, the Film Act removes that requirement to get film permits when filming in national parks, based on whether the filming or photography is commercial or not. The bill removes that existing commercial film permit requirement and replaces those laws with common sense rules to determine the need for a permit, and based, primarily on the impact it's going to have on the land and visitors. So the Film Act was part of a larger bill called the Explore Act, which had other bills and things about outdoor recreation, and it passed the House in April, and the Senate passed it through in, well, I don't know, a
I
week or
think it was
two
just
ago.
last week.
Yeah.
Yeah.
And the president, I
I
believe, has signed it. So,
Okay, I could not find confirmation if it had been signed yet.
mm,
And then I did read that it said at least for anything that's fewer than six crew
mhm.
members in a public access area, so where you and I could go, you're that I guess is common sense by definition. You're just not going to need to get permission.
No greater significant impact than a family visiting the park, as families do.
That's right.
So, um,
What I did not read up on this is like drone usage.
mhm.
Only because that's really been in the news here
Yeah,
this week in Dallas.
not to mention
Um,
New Jersey.
yeah, yeah, oh yeah, okay, sorry, all of that. But because one of the companies that puts on these fantastic drone shows
Oh yeah.
is not going to be putting on their portion of the drone show in Dallas and in part of New York and all kinds of other places, plus all of the are we being spied on drones on the East
Mm.
Coast? I would just think that anyone who's wanting to go film commercially or documentary, whatever it might be, in a national park, you need to also look at the drone requirements, which this may or may not relate to, as to being able to use a drone.
Yeah, I mean, I think that does have a kind of impact on not on just on the ecology, but the experience of all the other visitors
Right.
as well. So that would be something that maybe even under this law they would be able to come in and say, well, that's a meaningful
Yeah.
impact. So
Right. Right. Yeah. Have you been to any of those lights drone shows?
I have not.
Okay,
I've
take
seen
your
film of them,
kiddos.
but
It was we had one here in the big city of Louisville for when they lit the Christmas tree for the town. It was
oh,
very
cool.
fun, very
Oh, cool.
fun. So,
I actually years ago, a couple of years ago, I was at the NAB or the CES show in Las Vegas, the Consumer Electronics Show,
mhm.
and there was a demonstration in one of the showrooms of synchronized drones. 100 of them all
Yeah,
flying in,
yeah,
formation and things, and so I can only imagine if you add lights to that and they're flying around in the dark, it would be pretty cool to see. So,
yeah. They're forming all kinds of things,
well,
all
neat.
kinds of. Then I'm going, huh? Did they license all that? Is that fair use? So see, then it ruined my.
We lawyers can't just enjoy entertainment the
We
way other
can't
people
just
do.
we can't just enjoy it like regular people. No, we cannot. We cannot. So.
So, what is this about the style and vibe? Have you been following this case?
Yeah, and I'm just really, I was prepping early this morning and I'm like, college artist infringement
Mhm.
claims. And I'm like, oh no, that's collage. It's like that
Right.
doesn't make any sense. But yeah, I mean, we have, and you've probably seen artwork like this. I
Hmm.
love collage artwork. I'll just
Yeah.
tell you, it speaks to me. But this is Roberts versus Richard Beaver's gallery. There's multiple parties involved here. It's out of the Eastern District of New York. There was a 12B6 motion to dismiss, and defendants are the individual Richard Beavers who owns art galleries, the Richard Beavers
Hmm.
Gallery, and artist Lynthia Edwards. Uh, they succeeded in dismissing the plaintiff's claims of trade dress infringement, but not copyright infringement. And here's some of the facts on this. Roberts is the collage artist, works with a variety of museums, the Brooklyn Museum, the LA County Museum. Her works focus on Black children or adolescents using high contrast photographic fragments arranged in angular, unnatural arrangements, expressive hand gestures, lots of colorful fabric swatches, hand drawn painted details with a plain and unpatterned background. The plaintiff artist claims that her style is an unregistered trade dress. We're going to call that Robert's trade dress. The defendant is an art dealer out of New York. He actually contacted Roberts and said, hey, we would love to have some of your pieces in our gallery and be able to offer your works for sale. She declined that. So the case arises from the fact that allegedly defendant Beavers, who the individual in running the gallery, then encouraged and worked with the artist, also a defendant, Lynthia Edwards, to create collages that might have the same look and feel of those works by the plaintiff Rogers, and then those works created by Beavers were offered for sale in. I'm sorry, those works created by Lynthia Edwards were offered for sale in Beaver's gallery. According to the complaint, those collages created by Edwards closely mimic Robert's trade dress, including incorporating the same photographic source material plaintiff selected. And there was some actual confusion between the works. And Miss Edwards' works being called out as blatantly mirroring plaintiff's works in an article, and two causes of action, copyright and also trade dress. So under copyright, the subject matter and base elements were not protectable. So, using these various sources and combining them, and there was also third party content included in these collages. But what could be protectable is the assembly of all the elements. And the court debated on applying an ordinary observer test or a more discerning observer test because of the fact that there was public domain or third party rights involved in the collages, which were unprotected elements, and those unprotected elements were removed from the court's consideration. It looks like the court adopted a quote total concept and feel test closer to the ordinary observer test, looking at whether the total concept and feel of the works were the same. And the court did find that for some works, they were similar, and for others, it was not. So the court declined to grant the defendant's motion to dismiss as to certain of those works for the copyright infringement. So some of those stayed in and some of those were dismissed. And then we take a look at trade dress. I mean, I don't know. How does trade dress work for art? But let's see. The court determined that specific allegations regarding elements was not provided beyond the overall look, quote, of the artwork. The court cited a case involving greeting cards indicating that style is not legally protected as part of trade dress. And also the style elements were too generalized, colorful pattern fabric, stripes in blue and red. Further, the protected elements are generalized and expressed differently depending on each collage. So, as to trade dress, while style can be protected based on infringement on the look and feel of the work, that's the copyright aspect, protecting trade dress requires a little more specificity than the ordinary observer may glean. So, as to trade dress, the defendant's motion to dismiss prevails, but as to copyright, we've still got some copyright claims hanging out there to be determined.
Okay, so we'll expect to hear more after a trial, or maybe, well,
Yeah,
maybe.
yeah. maybe. But I mean, we've even got more about trade dress. What's going on with these influencers of the world?
Well, this one is happening kind of in your backyard, isn't it?
Yeah,
The
Western
Western
District
District.
of Texas.
Yeah.
Yeah.
So this is involving influencers on Instagram and TikTok and so on. This is Sydney Nicole Gifford and Sydney Nicole LLC, the LLC that she uses for business, is the plaintiff, and she is suing a former collaborator that she worked with named Alyssa Scheel, and her LLC, Alyssa Scheel LLC. They first met in December of 2022. They collaborated on a photo shoot together in January of 2023. And then a few days later, the defendant blocked Sydney from viewing her content. After that photo shoot, Alyssa purportedly stole Sydney's style and brand identity by publishing similar content and featuring the same or similar products and replicating Sydney's posts and content and style, essentially promoting all the same products. These are affiliate linked promotions, using the same typefaces, fonts, the same color schemes, making similar poses in photographs, creating a similar storefront. So really copying, or not copying, emulating Scheel emulating Gifford's work. Plaintiff had over 1 million views on one of her slideshows on TikToks, and defendants capped out around 35,000, I guess that is. It says 35, but I think that's probably 35,000. Anyway, plaintiffs also claimed that defendants were effectively impersonating Sydney Gifford. So plaintiff had registered her posts and photographs with the Copyright Office, so clearly in anticipation, I think, of bringing this suit. And she's bringing a case for copyright infringement, claiming that there were at least 30 photos promoting identical products, identical styling, tone, camera angle, text, claiming damages of $150,000, injunctive relief, attorney's fees, and so on. Also, vicarious copyright infringement. Although there are no does named in the claim, in the complaint, this is sort of a mirror of the infringement claim, but attaches to defendants that had the right and ability to supervise the content and an interest in the exploitation. But so what's interesting is Amazon and TikTok are not named in the case,
As
and
parties,
apparently
yeah.
no does. So that would mean a motion, petition to amend or something. Who knows? We'll see. DMCA violations, same basis as the copyright infringement. The idea is that by creating the duplicates was tantamount to removing copyright management information.
Can we talk about that one for a second before we move on?
Go for it.
Is that how that works?
I don't think so.
I don't think so either. I mean, well, prove us wrong.
I mean, if you look at...
we'll admit it when it comes around and we're wrong on that. But I don't, as hard as it is to sometimes even succeed when it's blatantly removed, if it's not enough to remove it and win on these generative AI claims, then how is it enough to go...
And if you go and look at
create new people? I mean, well, I believe both of these women have brown hair. That's probably about where our looks end. But, why couldn't I go do that?
Yeah. Well, and that's kind of...
How is that a copyright infringement?
Yeah, if you look at the photos side by side, the individual posts, yes, they're the same outfits. Yes, they're fundamentally the same color scheme, beige on white, with the woman with the brown hair and in a pose that they're similar. I wouldn't call them strikingly or substantially similar necessarily, at least not all of them. It really does come down to the style, or maybe that overall look and feel kind of a thing that we were talking about in the previous case. But these are not the same image where something has been stripped from the data field, the data file.
Right. It's not as if they put it through an AI generator and replaced one with the other, and everything else was the same.
So
at least to our knowledge, that's not what
so
is
one
going
example
on.
Is a picture of, they're showing off a cable knit sweater, and she's standing there with her in a pose with her arm on her hand on her hip and her knee popped out to one side, and it's a cute photo that shows off the sweater. Well, the other gal did a very similar pose, but can you claim that hand on hip and knee popped out is a
Okay.
copyrightable original? I don't think so. So
Are
there's
the Kardashians not the queen of all social media? We would all of us, even in my
right.
pitiful
Everybody's
attempts.
infringing
Yeah.
Kim and yeah, exactly. Kim and Courtney.
Right.
Anyway, to finish through the laundry list
Oh,
of
sorry.
the claims, no, the trade dress infringement. We just had a New York ruling on this issue. Plaintiff is claiming a trade dress of monochrome cream, gray, and beige colors with minimalistic styling. She's indicating that her 500,000 followers on TikTok is proof enough that she's created a source identifier. And they're also claiming that the defendants are copying not only the aesthetic, but Sydney's appearance and sound, right down to her haircut and manner of speech. While not in this cause of action, apparently Alyssa has even copied one of Sydney's tattoos.
Interesting. Yeah. I mean, and I guess they're saying the algorithm looks into, it must be the TikTok algorithm, looks about colors, shapes, and styling to suggest videos, which that's probably true.
Mm-hmm.
And so there's an effort to confuse the algorithm, I guess, to get more likes, more FaceTime, more
Okay.
views on the video of
I don't know that
the
that's
alleged
illegal though.
infringer. I don't think that is either. I mean,
Confuse the
we've come
algorithm or
right. We've come a long
capitalize on
way
the
on that one.
algorithm's
Yeah.
idiosyncrasies.
Yeah.
There's also a misappropriation of likeness claim, claiming that by styling herself in the same way, the claim is a misappropriation. And interference with business relations, unfair competition, unjust enrichment. And credit to John for coming up and identifying the case 2 pesos versus Taco Cabana from
I hadn't thought about
1992
yeah,
trade
Supreme
dress
Court.
case.
I hadn't thought about that, even though in Texas we do see that one
Yeah,
in any trade dress court filings, that one, the
yeah.
citation comes up to that for anything we're doing in Texas and probably should be pretty much anywhere. But yeah, and I will say, I mean, if you look at some of the pictures, there's no question the defendant does wear several outfits that are identical and post and but I just don't know that that rises to the level of a copyright infringement or a trade dress infringement or a DMCA violation or misappropriation
I think
in
that
and
there
of
are,
itself.
yeah, I mean, I think that there are lots of problems on the plaintiff's case in terms of originality, in terms of whether this is copyrightable subject matter, and whether there's substantial similarity if you get down to it, if it gets that far. And yeah, I mean, it is groundbreaking just because we're in this era where, influencers are doing what they do, but I don't see it.
Eh, Yeah, I don't either. Well, we might be wrong. We will watch where this goes. I mean, do I think the defendant could maybe, build her own brand and not
Well, right.
there's no doubt she's looking at this and replicating it,
But,
but
this
does
is
that
also,
rise to a cause of action? I
and
don't
it's
know.
worth mentioning, also this arises in adjacent to the fashion industry, where knockoff fashion is a whole thing. The fast fashion stuff, they all copy each other.
Yes, right.
So, although there
And
we have the
maybe
varsity athletic case and things like that.
so in Texas, we do not have a all of our misappropriation, name, image, and likeness during lifetime is case law.
Mm-hmm. Okay.
I just don't know. But the other thing would be if she really did did she make a claim of torturous interference? She did,
Yeah,
claiming that defendants essentially snipped in to create similar content for the same parties, undercutting her business relationship.
well, I don't think that your business relationship with Amazon or with TikTok is something that you can claim exclusivity of.
Well, but I'm
Anybody,
wondering if it was
mm,
certain face cream or products or something that she was an influencer for that the other girl jumped on
yeah, I
board
may be
with.
wrong. My understanding, and this is from talking to my students who follow these people, that, my students at Fashion Institute, right?
Oh, okay, got it.
They follow these people, and they're saying, no, this is all Amazon stuff. This is all Amazon associates where they are essentially
Oh,
Amazon
okay.
influencers and I guess TikTok too. But so Amazon, here's what we're promoting this week. Go out and promote it, and 100 influencers will be promoting the same sweater. It's just a question of, well, are these two so look-alike that they amount to some kind of, I don't see it as tortious interference, but maybe it is. What's interesting to me is I think that if this case gets in front of a jury, the outcome will be very different than if it's just decided at summary judgment. I think a jury would come and look at this and go, "Yeah, that's copying. Don't you punish her?"
Oh, yeah. But I don't know. You think if they, okay, jury of your peers, how many 25-year-olds are going to be on their jury?
Good point. Yeah, it's
Maybe I should start a parody TikTok and I wear all of those costumes.
there are a couple of people out there that do
35
this kind of stuff.
followers, maybe 35. That might
I
be the
don't know,
max.
Tamara. You may be more famous than you think.
Maybe.
Oh.
So, okay. So we're continuing on the TikTok theme. And
Mm-hmm.
I did we pick TikTok as one of our top
I don't
topics for
think
2025, for 2024?
I believe
Maybe
not.
not.
Mm-mm.
But here we're at the battle over TikTok's future has finally reached the Supreme Court with oral arguments scheduled for just a few weeks from now,
Mm-hmm.
January 10th, 2025, in a case that could reshape the legal landscape for free speech, national security, and tech regulation. At issue is the federal law passed with bipartisan support and signed by President Biden in April 2024, requiring TikTok to either divest from its Chinese parent company, ByteDance, or face a nationwide ban that would prevent new downloads and updates of the app in the US. The ban is set to take effect on January 19, just one day before President elect Donald Trump's inauguration. If it's enforced, the ban would prevent these new downloads and updates and gradually render the app non functional. I don't know if you've ever subscribed to something that they stopped updating and then you're dead
Sure.
in the water. Uh, it could disrupt operations like TikTok Shop and creator payments. I mean, obviously, that's, I think, one of the current concerns
Mm-hmm.
being couched as free speech. Not to say it's not, but it's a money generator for some people,
Mm-hmm.
and that money may go away. So the DC Circuit Court of Appeals previously upheld the ban, finding it does not violate the First Amendment. The court ruled the law targets foreign ownership, not the platform's content, and determined the ban was a narrowly tailored response to compelling national security concerns. The government continued to argue TikTok's ties to China pose significant risk, including data harvesting and potential manipulation of content, though much of that evidence remains under seal. Of course, TikTok has challenged the law, arguing it infringes the First Amendment rights of 170 million U.S.
Mm-hmm.
users. Uh, the ban is speculative rather than concrete evidence. It's described as the law of unprecedented act of censorship that stifles free speech and singles out unfairly a single platform.
Hmm.
So there's also been more news related to President-elect Trump.
Yeah.
He has filed a brief, which I don't know how often that happens, but it's happened to the Supreme
Yeah.
Court requesting a delay of the ban's enforcement. As I just mentioned, it's supposed to go into effect the day before he comes into office. And Trump's brief highlighted his intent to address the issue through diplomatic means. After he takes office, arguing that banning the platform prematurely would undermine his ability to manage foreign policy and protect a platform vital to free speech for millions of Americans. His brief did not address constitutionality issues directly, but emphasized his own negotiation expertise and his significant following on TikTok. Who knew? Which he views as a unique medium for political speech. This is when my adult niece is like, "Hey, Tamara, I'll get you set up on TikTok." I'm like, "I'm on TikTok. I just don't use
Right.
TikTok."
Right. Now it
I
seems
had
to
to
me.
figure it out because of clients, but it's my personal choice not to use
Right.
it.
Right. So it seems to me that if I recall correctly, when he was president in his previous term, banning TikTok was his idea at one point. But
I am not clear on that.
I
It's
could be
funny.
wrong.
Again, I kind of assumed he wouldn't be on TikTok
Hmm.
because he has his own social media channel.
Well,
Channel.
I,
Channel.
right,
But
right. But I
who
think
knew?
before all that, but at the
Okay.
time when they were talking about when he was very active on Twitter, and there was the deplatforming and stuff going on. I vaguely remember the national security, or trade negotiations with China component of things being him engaging in some rhetoric, at least about banning TikTok. And so, different president comes in and enacts it, and now it's something to rail against. So it's all politics at
I
some
don't know.
point.
Is there a basis for the Supreme Court to grant a stay?
That's a great question. I mean, I guess they
I don't
could.
know.
Maybe they could decide that the case will be moot in one day, or or something. And so, well, no, you said it goes into effect on the 19th. So yeah, I mean, if Trump had said, "Well, I'm not going to enforce it," then there'd be one day of enforcement before it would be lifted or something. I don't know.
Hmm.
So
Well,
maybe there's a moot or ripeness kind of a thing that could come into play there, but uh, I don't see it. It'll be interesting to see what the Supreme Court does, and whether they reference the president-elect's um, briefing in their opinion when they render it. So, but yeah, should be an interesting first few weeks of the term for him, and that.
sure.
Well, also related to social media, I want to say thank you to Mickey Glazer for this bit of news that he shared with us. Everybody,
Mikey.
Mikey, is it?
Mikey. It's
Oh,
Mikey.
oh, okay.
I know. Sorry, Mikey.
I apologize.
No, that's okay. He sent it to me phonetically, so I would get it correct because I
Got
think
it.
I've called
All
him
right.
Mickey before too.
All right, Mikey. Well, anyway, he tells us and reminded us, or made aware, that Alex Jones, the conservative media figure, conspiracy theory host of InfoWars, was sued for defamation by the parents of victims of the tragic school shooting in Sandy Hook Elementary School in Connecticut a number of years ago now. Those families were awarded almost $1.5 billion, and Jones and his company, ironically named Free Speech Systems, filed for Chapter 7 bankruptcy. And you may have heard also that the satire site The Onion was the high bidder in the auction of assets. And then last month, that bankruptcy judge rejected that sale because the amount bid was just too low and wouldn't provide adequate compensation for the family. So basically said, go back and try again. But in an interesting twist, Twitter X has filed an intervening objection with the court as regards the sale of the Twitter account. As distinguished from the content that was posted on that Twitter account. X claims that under its terms of use, it, as the owner of the services, grants users a personal, worldwide, royalty-free, non-assignable, non-exclusive license to use its software and to use the services. And thus, the account itself can't be sold in the auction.
Mm.
So far, no ruling. It's a 67-page motion, but most of that is exhibits. The legal substance lands in the first 15 pages at the front of the document, and really just comes down to the terms of service. Who owns it?
Okay, so at Tamara Bennett, it's such a thriving Twitter account, X
Mm-hmm,
account.
mm-hmm.
So if there was another Tamara Bennett, I could not assign my handle to that person within the terms of use. I thought I could.
I think that I think Twitter would have to intermediate that transaction, according to this kind of an
Only
analysis.
because years and years and years ago,
Yeah,
I had clients who had some bad actors and we had to go
sure.
in and get their handle. And
Well,
we were able to do that. And so if you've got everybody agreeing, yeah, I'm just kind of confused on
yeah.
how, if it's an asset of the bankruptcy, why the bankruptcy can't.
Well, I think also there's the trademark, both common law and registered brand part of this, where if the account in question is Infowars and that's a registered trademark, I think it is, and the buyer acquires the trademark, then that puts us in position of, would
They're
Twitter then be an
right.
infringer?
Well, I don't know because I think they are a assignee, have acquired the rights appropriately and should be able to step
Oh yeah,
into the shoes of that account.
yeah,
I don't know.
yeah.
We'll see. We will
Well, we'll see
see.
what the court says eventually
Yeah.
when and if a new auction happens and the sale eventually goes through. We'll find out. We'll find out. Well, let's talk about our completely unscientific tally of top stories from 2025, 2024. I think it's safe to say AI has been the overriding theme in
The
2024.
overriding our AI corner, and I was like, I don't even know if we need to give everybody a rundown of the AI corner, but just to say, we've talked a lot about AI.
There are dozens of cases ongoing. So far, very few substantive decisions. I think there was one a few weeks ago that um, uh, that went against some of the publishers that were suing, but a lot more to be done. I think 2025 is going to be a very active time in the AI arena, and
Right. And I just also as a practice reminder, please note that many uh, bar associations and as well as the ABA are making rulings regarding how we can and
yeah,
cannot use AI in our practice and what we may or may not need to disclose about that use. So,
I think this all sort of lands in the area of that technological competence requirement that we have.
mm,
We have
oh,
to
we
stay
do.
up on the technology, and right now everything is in so much flux that I think we just have to be paying attention. So,
We do, and I would just say be aware if you're, trying out these different
mhm,
generative AI resources, you have to, on most of them, be at some level of a paid subscriber to have even the first inkling of confidentiality,
yeah, yeah,
and that your content, what you submit, will not be used for training purposes. So be aware
yeah,
of the risk.
yeah. We also saw a lot of activity in the copyright grant termination arena. You want to take some of these?
Yeah, so episode 168 this year,
Hmm.
Warner Chappell versus Neely, a Supreme Court holding. The Copyright Act entitles a copyright owner to obtain monetary relief for any timely infringement claim, no matter when the infringement occurred, not limiting us to what I've always felt was what we needed to do was just that 3-year look back on damages, but that has expanded to a
Hmm.
longer potential look back period.
And yeah, and we also discussed the Internet Archive book scanning case we talked about briefly earlier in this episode. That one back in episode 172, we talked about it, and the open library program does amount to copyright infringement according to the Second Circuit. And I apologize, I had skipped when I pitched it to you, and you did the Neely case. Now we talk about copyright grant terminations in the news.
I was like, oh, I don't think, but okay, I'll roll with it. Okay, we did have a lot of copyright grant termination news
Mm-hmm.
and in the courts this year. A case we've talked about multiple times over the years relating to Cher. And now we have a final resolution that Cher prevailed in a lawsuit against Sonny Bono's widow, Mary Bono, over copyright royalties from the Sonny and Cher joint song catalog. The dispute arose when Mary Bono, as the beneficiary of Sonny's estate, exercised her right to terminate the copyright assignments made by Sonny to their publishing company, Wixon Music Publishing, in 2016. And this termination effectively ended Cher's 50% share of the royalties that she was entitled to for the big hits, I Got You Babe, and The Beat Goes On.
Mm-hmm.
Cher sues in 2021. We go through a variety of iterations, but in the end, as a result, the judge upheld Cher's position that the divorce settlement agreement between her and Sonny took precedent over the termination clause and that Cher was entitled to continue to receive her 50% share of the royalties. As a result, Cher is owed approximately $418,000 in withheld royalties, and she'll continue to receive her share of royalties from the Sonny and Cher catalog. So it didn't mean there was no right to a termination that Mary Bono may have had. It just meant that in this very particular situation, her rights to receive those royalties survived.
Royalties as distinct, revenue essentially as distinct
As
from
distinct
ownership of the copyright.
from
Yeah.
ownership. That's right.
Yeah. Well, the screenwriter for the film Roadhouse, Lance Hill, has sued MGM and Amazon over remaking, claiming that he had terminated the grant. Screenwriter of the original '89 film filed this lawsuit for copyright infringement, claiming that Amazon had ignored his ability to reclaim the rights for his 1986 screenplay as they mounted the remake starring Jake Gyllenhaal, and that the film also used artificial intelligence to replicate the voices of actors and so on during the SAG strike. I don't know what that has to do with him, but okay. And the lawsuit alleged that Hill filed a petition with the Copyright Office requesting, terminating the grant. That was set to expire in November 2023. And Amazon proceeded with the film despite those claims. And Amazon and MGM denying those claims, claiming the lawsuit is completely without merit and film doesn't use any AI in place of actors' voices. I think that case is still positioned to
It's
move toward
still
trial.
going, so I just went and took a peep at it this morning on Pacer, and some decisions have been made, and there's now an appeal pending to the Ninth Circuit.
Oh, okay.
So I think it's just some procedural things that have been pushed up to the Ninth Circuit. So it's still
Okay.
moving forward.
Yeah.
Que sera, sera. Anyway,
Whatever will be, will be.
whatever will be, will be. Jay Livingston granddaughter sued her mother for exercising copyright termination rights in the hit Que Sera, Sera and other popular songs. The court granted the defendant's motion to dismiss in both cases. In the first case, the court found that the plaintiff's claims were subject to binding arbitration. In the second case, the court determined that the plaintiff's claims were invalid under Section 203 of the Copyright Act of 1976, that being one of the termination provisions. The court's decisions were based on the facts alleged in the complaints and the applicable law, including the arbitration clauses in the agreements and the provisions of the Copyright Act. I don't know which episode we talked about this previously. There's probably been a couple. Go back and listen. We have a lot more details related to the facts playing out here. But again, it's one of those situations where there may have been an estate plan in place with multiple layers of trust, which is what I recall about this. And that does not supersede one's rights to go in and terminate those grants. And just recently, we talked about the MLC must administer royalties in accordance with the Copyright Act's termination provisions, ensuring that copyright owners, and again, this is going to be related to music publishers, regain control of their rights when termination occurs. It ensures fairness and accuracy in royalty distributions, benefiting both creators and users of musical works. Go back and listen to maybe the last one or two episodes, 73, 74. We talked more in detail about that one.
Well, the case of Vedder versus Resnick is a looms large, let's put it that way, because in this case, the Louisiana District Court has broken with existing precedent and adopted a pretty novel theory of recovery that statutory termination of a copyright grant, as well as contingent copyright renewal rights, apply worldwide and are not limited to the U.S., as most courts have held up until now. So I think this is going to be big in the news in the next year or two as well, there's a lot at stake there. So I think we'll see a lot of action on that one. And then Two Live Crew, right? Their Little Joe Records versus Ross is their bid to reclaim the sound recordings based on the 1990 deal was successful after the judge granted their motion for summary judgment that copyright grant termination rights are personal rights and survive the bankruptcy of the company. And the jury found no work for hire in the creation of the work. So they got the songs back.
Yeah. I don't know if it was the songs or the sound recordings, or both.
Sorry.
Yeah, the recordings, I think so. So how did we do on our predictions for 2024, Gordon?
Well, we did say that AI was going to be the big story of the year. We said governments around the world will wrestle with AI regulation. I think that's not been the case so much. as has been the case, that it's been a lot of litigation. So we'll see what happens with those trials, and then it wouldn't surprise me if this next year we see more governments getting into the fray as well about
And
how to
I
deal
know
with these
we've
things.
talked about the EU regulations,
Yeah.
as well as I know there's pending or introduced regulations in the House and the Senate here, so we'll keep an eye on those as well, as well as state law
Mm-hmm.
related to our practice areas for generative AI and the Elvis Act that passed in Tennessee.
Yeah.
So
Yeah, there's been some. It just hasn't been quite as busy as I think we might have expected.
we would have thought.
Yeah, yeah. Um, Section 230 under siege was another prediction we had, and it's been quiet on that front, hasn't it? Relatively so.
I think so. I'm not sure if we covered maybe one case this year on that, on Section
Yeah.
230. I don't even know if we did.
Well, I think that's another one we can carry forward into 2025 with the new administration and the GOP in control of both houses of Congress. I think we might see some movement on that, to the extent any movement in Congress is possible anymore. But I know that some folks, well, on both sides of the aisle, really have been feeling that Section 230 is ripe for an overhaul, and the big internet companies don't need the protections so much anymore, and the internet is a robust place, and all of that. I think some of the Section 230 litigation has gone in the interesting direction of finding that it isn't as expansive as we once may have thought. So it'll be interesting to watch what happens there.
Yeah.
And then the TikTok ban at the end of 2023, we were saying the state of Montana's TikTok ban, which was enjoined in November of last year, right? Or no, it was enjoined.
No, just enjoying just now,
Just last
November
month.
2024. Yeah.
Right. So I guess bigger fish to fry with a federal TikTok ban. Montana's is sort of irrelevant in that scope of things, but yeah, I think we hit it on that one. Free speech regulation and the TikTok ban being the big story.
And I know we've kind of made it the big story maybe a year, 2 or 3 years ago about all of the college athletes and NIL. I'm going to forecast that too. I think there was more happening this year in that arena that we just, didn't put into our rundowns, but I think we're going to see a lot next year, as well as a whole revamping of the college football.
Yeah. Oh, well, you froze a little bit there, but
I know I did, and that was just a terrible looking face there when I froze. I was just saying I think we're going to see more on the NIL and student athletes this coming year, and then I was just joking to say, which is true, there's going to be another revamp of the college football playoffs, but that's not really our topic to cover.
Well, since you mentioned it, my Ducks are in the Rose Bowl this year. I'm looking forward to that. So.
Yay, go Ducks! We will. I don't know, who are they?
That's the extent of football that I follow.
Well, and that's one of the playoffs games, though, as well.
Yeah.
Well,
I don't know who's playing, but I'll
my
be rooting for my
Sooners were-
Ducks. So
Yeah, my Sooners were a disappointing year, but Vanderbilt did great, and that's my husband's team. So
okay, all right,
yeah.
Okay, well, I think we have exhausted our rundown for today, and that brings us to the end of this episode of Entertainment Law Update. And as always, I want to say a big thank you to our listeners, and we're on YouTube now, so I'll say viewers as well, for spending your time with us. We know your time is valuable, and we hope we add value to the time you spend with us, so thank you for that. If you have feedback, and we hope you do, please, leave it for us using the comments on YouTube if you're watching, or if you're listening, use the voice widget on our website at entertainmentlawupdate.com, or you can email us at entertainmentlawupdate@gmail.com. I have pretty much stopped using Twitter X, but we have a handle there at entlawupdate. But you can also find me on most other social media as G Firemark. What about you, Tamara? How can folks find you?
Yeah, folks can find me at Tamara Bennett, TamerABennett. I'm still going to be available. You can hunt me down at tbennettlaw.com, at createprotect.com. I will be coming soon to harperbates.com as I join the new firm in just a few days on January 2nd. Most social media at Tamara Bennett.
And you can find my website at firemark.com or email me, gfiremark@firemark.com. And as I said before on social media, gfiremark is the handle to look for. Let's give a big shout out to our crack team of volunteer contributors. We have managing editor John Janicek. We have Charles Thorne, Alexis Allen, Violet Zhang, Tasha Spear, and Dawson Holder. And I think I have a couple of new additions to the team coming early in the year. So,
Oh,
but if you are
yay.
interested in joining the fun as part of the family of contributors, reach out. entertainmentlawupdate@gmail.com is the best email address to use. And with that, I will say thanks for watching. That wraps up this episode of Entertainment Law Update.